Welcome back to the Legal Alternative Podcast with me, Sam Pawson, joined remotely today by Nils. Nils, how are you?
Very good, Sam. How are you?
Very good. Yeah, we're not together both had a bit of a crazy work week, so having to do this remotely this week. Bit of a, big update for both of us, I think, in some things, both of our areas that got a lot of legal press attention this week. Bit of a Christmas feel as well, Nils. I think it's our last one before the Christmas break, so bit of a Christmas catch-up as well. I think you're up first, jury trials.
I am, yes. I was actually in the Leeds office earlier this week, and in the dock at Leeds, our colleague Matt Perry always puts Radio 2 on, which for someone of my generation is fantastic.
Yeah.
And about 12 o'clock, it switches from Vernon Kay to Jeremy Vine. And Jeremy Vine was talking a lot about this on Tuesday. And a lot of it was actually about Magna Carta. I am less inclined to spend time speaking about Magna Carta, more inclined to talk about the actual practicalities of this.
Yeah.
So that the government are proposing, for all but the most serious crimes, to scrap jury trials. Since COVID in particular, there has been a huge backlog of criminal cases, particularly Crown Court cases. I have some cases currently going through the system, which by the time they will reach trial will be 4 years old.
Yeah.
And some really serious accusations, which is not ideal for the complainants. It's not ideal for those that are subject to those allegations. And it's not ideal for actually the case being fresh in everybody's mind.
Yeah.
And what the government is proposing to do, as I say, for all but the most serious offences, is scrap jury trials. So if you were accused of a really serious financial crime, you wouldn't have a jury trial. So whether this will be a permanent reversal, it will be interesting to see. Obviously, if it goes through. My own two penneth is the government are looking to change something to get rid of a backlog. And this isn't getting political, by the way, but the government are looking to change something to get rid of a backlog. The fact that trials are by jury is not what's causing the backlog. There are other reasons for that. I would prefer to see those issues addressed. We have had juries in this country, and this is why Magna Carta has been discussed on Radio 2 for a long, long time. And the government is proposing to get rid of something that for generations I think has served us quite well. Having said that, I think there are arguments for scrapping jury trials. I just sit in the camp that they actually work quite well. What concerns me is, does this take a fundamental part of our democracy really out, never replace it to try and resolve something that could be temporary? I think if you invest in the system and cure the reasons why there is a backlog, which is a lack of resource for everything that the courts do and that the police do, that would be a way of curing the backlog. The difficulty I suspect the government has is that this isn't a vote winner. If you were to correct the criminal justice system, not many people are going to vote for you because of that, as opposed to if you corrected the problems in the NHS. Everybody uses the NHS. Criminal justice is not really a vote winner. So I can see why the government have done this. As I say, it's not a political dig from me at all. I think the system of juries has served us well in favour of keeping juries for those offences where it is appropriate in the Crown Court and looking at other things to try and get rid of the backlog.
Yeah. I'd agree, Nils, and again, it's going to echo some of the things I'm going to talk about in my update. We, in an employment tribunal setting, have the same backlog. That's not, as you say, that's not because of how hearings in an employment setting work. It's a very informal setting with different court buildings, a lot done remotely. The issue is, as you say, a massive underfunding to get judges in, to get the system working correctly. This is a chronic underfunding issue, and I completely agree with you. So I think there's and that I think is getting lost. I think there is a debate on juries and access to justice and as you say, those Magna Carta type issues. But that is, to me, as you say, that's probably separate to a funding issue.
Yeah,
there is a philosophical debate to be had, but I think you're absolutely spot on that philosophical debate is being used to, instead of a question about the courts being underfunded. So
the other thing is this will increase the workload in the magistrates' court.
Yeah,
that they can't cope now. This is not a criticism of the individuals who work within magistrates' court. They're not well resourced enough at the moment to cope with the workload they have. We'll have to see. And the other thing is, of course, you're either just one side or just the other side of when this cutoff happens. You're thinking, if I got a judge on that day or I get a jury, what would the difference have been? So, but I remember doing A-level law and this being a debate, should we have juries?
Yeah. See, lots of jurisdictions don't have them.
Yeah.
And some that do have juries, look at our friends over the pond in America have real issues with jury tampering and other things. No perfect system, but one, it's going to have a really big impact. Really, I'm sure the listeners will have their own views on it.
Yeah, absolutely.
Perfect. Similar, big hitting topic really for me. I've been promising for the last 2 weeks an update on the Employment Rights Act, Nils. It's finally came. It came obviously the Thursday after the budget. And we have finally had an announcement, and it's been obviously reported in the press as a capitulation by the government on day one rights. For listeners who aren't aware, day one rights was a fundamental pledge in the Labour manifesto. The critical thing we're going to talk about today was unfair dismissal rights at day one. Obviously, current system, you need 2 years continuous service to bring a claim an unfair dismissal. The suggestion was that was going to become a day one right with some sort of probationary period. That has now been scrapped, and what we're seeing is a reduction in the qualifying period from 2 years to 6 months. So essentially, after 6 months, you can bring an unfair dismissal claim. So I think a few things I wanted to talk about today, Nils, is obviously it's been reported in the press as this big kind of watering down of a election pledge and obviously all the politics that goes around that. The thing I think's been lost in the reporting, and this is a line I'd be taking if I was the government. This is still absolutely huge in terms of the consequence. As you all know better than most in practice. We're probably both just about old enough that it was 1 year to 2 years. But for us, vast majority of our working practice, we've had two years of service. It's the first question we ask on any call. How long's the length of service? So 6 months is, I speak to this as a manager of people as much as an employment lawyer. 6 months is an incredibly quick time to obviously review someone and embed them in the organization, see what they're like. And this is going to be an absolutely drastic impact in the world that we work in and fundamentally change our jobs. And for the listeners, it's going to have huge impacts on recruitment, workforce planning, management of staff. And I think that's been lost somewhat in the reporting. We're fixating on, it's not day one right. But even the day one rights, they were going to come with some form of probationary period. This is a absolutely fundamental change that will impact every single employer. So I think that's the point that I wanted to get across today critically.
It is. It's a massive. I think we probably had 2 years of 1 year service.
Well,
certainly not a long period of time because it was the coalition government that brought it in, wasn't it?
It was.
So maybe 12 months of a year's service.
Yeah. It passed me by. We obviously in our team meeting speaking to both our dear colleagues, Paul Campbell, who said it did used to be 6 months.
I didn't know that.
30 plus years ago. So you obviously passed both our working careers by. But yeah, so obviously for the vast majority of listeners, all their working life, we've had probably 2 years, if not one. So it's a really fundamental change. The other update for the listeners is, when is this happening? And again, we don't have firm dates on this. There's been some reports today about it. Initially, in the roadmap we were working to, we thought day one rights was going to be 2027. There is some discussion now that Angela Rayner and a few of the backbench MPs who are working on these proposals are pushing for 2026. The reason for this is because actually it is not we don't need a fundamental new piece of legislation. This is changing 2 years to 6 months. The legislative program is different. So there's some suggestion that this can come in quicker. Whether it does, I would still hold some caution. If I was to bet, I still think it will be 2027. Because of the impact. I think they will. The business lobby will want some notice of this. And obviously, there's been an agreement with the unions, an agreement. I would be surprised. I say it's contrary to what has been reported, which is 2026. My gut would be early 27.
Yeah, it's a big change to bring in quickly because the practical effects. I've not ever even been in the House of Commons, so I don't know practically how quickly you could push it through, but I would imagine very quickly. And it depends which side of the fence you sit on, doesn't it? If you're a business owner, you're probably thinking yet another piece of yet another blow. If you're a member of Unison, you're probably thinking, yeah, this is more where we want it. Most people will sit in the middle and won't care. Well, it's probably not another big vote winner.
No, but yeah, they say the general employment rights bill it carries public support. The polling on it, as I say, I would generally agree with you. As you say, if it impacts you, if you've been let go at 23 months, quite understandably, this will be a a very popular move. I think the other impact is kind of where you were talking about is the tribunal. This is undoubtedly going to have a massive impact on the number of claims. There's slight difference of opinion on that. We were talking about in our team meeting last week, and there is some suggestion that what this may do is throw out or change the kind of spurious discrimination claims that you get when employees have less than 2 years of service, where they obviously it's probably in reality an unfair dismissal claim, but they haven't got service, so a form of discrimination is pleaded to try and get a claim in. The suggestion is this might simplify claims, that these what would probably be an unfair dismissal claims will now be treated as such, which, as you'll know, in practice simplifies the tribunal process somewhat.
Yep.
So there is some view that actually this may streamline the tribunal process somewhat. I just think pure volume is going to add to it. Just 2 years to 6 months, it's just going to add more claims. I take the point that, yeah, there will be some that aren't, but they're pleaded differently. But I can only see this as an increase in total claims in the tribunal of a system that is struggling.
And then they'll have to come up with something similar to what they've done with the criminal system, which is how do we modify the tribunal to cope,
Yeah.
I would imagine. But I don't know what that could be.
Yeah.
I suspect it will be just judges again, get rid of wing members, or who knows?
Which I think, which we're seeing already, a lot more remotely, a lot more probably straight to a hearing, like contract claims are now. So from ET1, you're straight to a hearing, no preliminary hearings, just straight in. I think you'll probably see on some basic unfair dismissal claims. So yeah, a lot to come out of this, which obviously we'll report on as always.
Yep, absolutely.
At the office, Nils, you said it's Christmas for us in terms of this last podcast. I think before the New Year break, we're both away over the Christmas period, and festivities starting already. I'm at the pantomime tonight with our good friends at Theatre Royal Wakefield, who always put us some tickets away every year. So taking the kids to that tonight, which like you, Nils, and we're now at the age, and because we get lovely seats in the theatre, we sit quite near the front of the stalls. So I'm currently having kind of palpitations that I will be picked as the middle-aged bald man to go on stage. So it's we're fingers crossed I'll avoid that. Although the kids would love it. So yeah, looking forward. Jack and the Beanstalk tonight. How about you?
Good stuff. Well, I've got plans to go to Spain to do a run. We'll see how far I get on that run. I haven't done much training. I just wanted to mention, and we haven't actually formally announced this yet, that Halifax Panthers are our latest sports club that we've become legal members with. So really excited about that. They've got a shirt launch next week that I'm really looking forward to going to. So looking forward to that as a bit of a Christmas event as well.
Fantastic. I think it takes our professional clubs double digits, I think. So yeah, very exciting. So yeah, that'll be good. Yeah, it's just down to the share with the ground share.
Yes, well, I might actually have two clubs at one ground. So 2 clubs that we sponsor Huddersfield and obviously work with it. So I think that's probably a world first.
Absolutely. Yeah, brilliant. Top stuff. So just from me, big thank you to all listeners, subscribers for joining us over the last year. Big thank you for me. Wishing everyone happy Christmas and a great new year.
And for me, thank you.